Hi, I'm Jim Covington on behalf of the Illinois State Bar Association. Today is March 22nd, and I'd like to welcome you to this week's issue of ISBA Statehouse Review. I'd like to talk to you about 5 bills. The first one is House Bill 3944, filed by Representative Elaine Necritz from Northbrook. This creates an exemption in the eavesdropping article from exempting citizens from a Class 1 prosecution for recording. They can now film, but they can't record a law enforcement officer doing public duty in a public place. This bill went down to defeat yesterday in the House on a 45 to 59 to 1 vote. The second bill I'd like to talk to you about is Senate Bill 3763, introduced by Senator Emil Jones III from Chicago. This requires courts to, in every DUI disposition, whether the supervision or not, to send the defendant to a victim impact panel to listen to these folks. And it's now discretionary. The judge or the circuit may decide to send a defendant to that. This makes it mandatory. And that bill is going to be heard in Senate Judiciary Committee next Monday. The third bill I'd like to talk to you about is House Bill 5214, introduced by Representative Randy Ramey from Carroll Stream. It allows a driver to obtain a MDDP using a SCRAM device instead of a BAID device. The SCRAM device would be an alternative to the BAID device. It also allows a court to require its use as a condition of supervision, conditional discharge, or probation. This bill is on second reading in the House and still alive. The third bill is House Bill 5262, filed by Representative Art Turner Jr. from Chicago, and it amends the videotaped interrogations part of the criminal code, and it allows the use of statements made by adults and minors in homicide cases and other death investigations to be used in later criminal proceedings, even if the statement is not electronically recorded. There's great concern over this bill on whether it's watering down our videotaped interrogation statute. It's unclear what the bill is actually trying to do, which is always a dangerous sign, even if you can agree upon what we need to do if the language is simply unclear. That bill is on second reading in the House. The fifth and final bill I'd like to talk to you about is House Bill 5434, filed by Representative Ann Williams of Chicago, amending the post-judgment collection procedures. There was a lot of articles about debtors' prisons in Illinois last fall, which were somewhat misleading. This is an effort by the Attorney General to go in and clean up and make more clear, give debtors more notice, body attachments, and other things in post-judgment collection procedures. Essentially, it's going to do 3 things, which are as follows. Citation and rules to show cause should be served by process instead of mail. 2, there should be a confirmation of the judgment debtor's ability to pay from non-exempt assets. And 3, the court should confirm the existence of non-exempt assets before approving pay plan orders. This is on second reading in the House. And on behalf of the ISBA, thanks for listening, and we will see you next week. Thank you.